the appeal, the Queen on the application of Nicklinson and Lamb, and the Queen on the application of AM.
These appeals arise from tragic facts and raise difficult and significant issues, namely whether the present state of the law in England and Wales relating to assisting suicide infringes the European Convention on Human Rights, and whether the policy published by the Director of Public Prosecutions relating to prosecutions of those who are alleged to have assisted suicide is lawful. Section 1 of the Suicide Act 1961 decriminalised suicide. However, Section 2 of that Act provided that encouraging or assisting a suicide remained a crime, but that no prosecutions could be brought without the permission of the DPP. That section has been amended in 2009, but remains effectively the same. Following a decision of the House of Lords in 2009, the DPP published his policy for prosecutors in respect of cases of encouraging or assisting suicide, setting out his policy in relation to prosecutions under Section 2. In the first appeal, Mr. Nicklinson suffered a catastrophic stroke some 9 years ago, since when he has been completely paralysed, save that he can move his head and his eyes. For many years he has wanted to end his life, but could not do so without assistance, other than by self-starvation, a protracted, painful and distressing exercise. He wanted someone to kill him by injecting him with a lethal drug, but if necessary he was prepared to kill himself by means of a machine invented by Dr. Nitschke, which after being loaded with a lethal drug, could be digitally activated by Mr. Nicklinson using a passphrase via an eye-blink computer. Mr. Nicklinson applied to the High Court for 1, a declaration that it would be lawful for a doctor to kill him or to assist him in terminating his life, or if that was refused, 2, a declaration that the current state of the law in that connection was incompatible with his right to a private life under Article 8 of the Convention. The High Court refused Mr. Nicklinson both forms of relief. He then declined all food and died of pneumonia on 22nd August 2012. Mr. Nicklinson's wife, Jane, was then added as a party to the proceedings and pursued an appeal. Mr. Lamb was added as a claimant in the Court of Appeal. Since a car crash in 1991, Mr. Lamb has been unable to move anything except his right hand. His condition is irreversible and he wishes to end his life. He applied for the same relief sought by Mr. Nicklinson. The Court of Appeal dismissed the appeal brought by Mr. Nicklinson and Mr. Lamb. In the second appeal, an individual known as Martin suffered a brainstem stroke in August 2008. He is almost completely unable to move and his condition is incurable. He wishes to end his life by travelling to Switzerland to make use of the Dignitas service, which enables people who wish to die to do so. Martin began proceedings seeking an order that the DPP should clarify and modify his 2010 policy to enable responsible people such as carers to know that they could assist Martin in committing suicide through Dignitas without the risk of being prosecuted. Martin's claim failed in the High Court, but his appeal was partially successful in that the Court of Appeal held that the 2010 policy was not sufficiently clear in relation to healthcare professionals. Mr. Nicklinson and Mr. Lamb have appealed to the Supreme Court in the first appeal, and the DPP has appealed, and Martin has cross-appealed in the second appeal. So far as our judgment is concerned, by a majority of 7-2, we dismiss the appeal brought by Mr. Nicklinson and Mr. Lamb. We unanimously allow the appeal brought by the DPP and dismiss the cross-appeal brought by Martin. Each of us 9 justices has given a judgment. On the first appeal, we unanimously hold that the question whether the current law on assisted suicide is incompatible with Article 8 lies within the United Kingdom's margin of appreciation. In other words, it's a question for the United Kingdom to decide. 5 justices hold that the court has the constitutional authority to make a declaration that the general prohibition on assisted suicide in Section 2 is incompatible with Article 8. Of those 5, 3 justices declined to grant a declaration of incompatibility in these proceedings, but 2 would have done so. 4 justices conclude that the question whether the current law on assisting suicide is compatible with Article 8 involves the consideration of issues which Parliament is inherently better qualified than the courts to assess, and that under present circumstances, the courts should respect Parliament's assessment. On the second appeal, the Supreme Court unanimously allows the DPP's appeal. The exercise of judgment by the DPP, according to the circumstances of each individual case, is proper and constitutionally necessary features of the system of prosecution in the public interest. In the light of the Supreme Court's conclusion on the second appeal, Martin's cross appeal does not arise. Turn now to the reasons for the judgment. The first appeal: is the present law on assisting suicide incompatible with Article 8? The Supreme Court unanimously holds that according to the case law of the European Court of Human Rights, the question whether to impose a general ban on assisted suicide lies within the margin of appreciation of the United Kingdom. In other words, it's a domestic question for the United Kingdom courts to decide under the Human Rights Act 1998. It's also of the unanimous view of the court that Section 2 engages Article 8 as it prevents people who are physically unable to commit suicide without assistance from determining how and when they should die. Accordingly, in the words of Article 8, it can only be a justified interference with those people's rights if it is, and I quote, necessary in a democratic society for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. Lady Hale, Lord Mance, Lord Kerr, Lord Wilson and I hold that within the constitutional settlement of the United Kingdom, the court has the constitutional authority to make a declaration of incompatibility in relation to the blanket ban on assisted suicide. Lord Mance, Lord Wilson and I conclude that while the question of assisted suicide is a difficult, sensitive and controversial issue on which great significance will be attached to the judgment of the democratically informed legislature, this does not mean that Parliament's decision is necessarily determinative. However, while the sensitive and controversial nature of this issue does not justify the court ruling out the possibility that it could make a declaration of incompatibility, it would be inappropriate for a court to decide whether Section 2 is incompatible with Article 8 before giving Parliament the opportunity to consider the position in the light of this judgment. The main justification advanced for an absolute prohibition on assisted suicide is the perceived risk to the lives of vulnerable individuals who might feel themselves a burden to their family, friends, or society, and might, if assisted suicide were permitted, be persuaded or convince themselves that they should undertake it, when otherwise they would not do so. A system whereby a judge or other independent assessor is satisfied in advance that someone has a voluntary, clear, settled, and informed wish to die, and for his or her suicide then to be organised in an open and professional way, would arguably provide greater and more satisfactory protection for the vulnerable than the system which involves a lawyer from the DPP's office inquiring after the event whether the person who had killed himself or herself had such a wish. The interference with Mr. Nicklinson's and Mr. Lamb's Article 8 rights is grave, and the arguments in favour of the current law are by no means overwhelming. However, even if it had been appropriate to issue a declaration of incompatibility at this time, Lord Mance, Lord Wilson and I would not make a declaration in these proceedings. In the courts below, the main focus was on Mr. Nicklinson's submissions that necessity should be recognised as a defence to murder, whereas before the Supreme Court, the case advanced was that a machine like Dr. Nitschke's would offer a feasible means of suicide for those who have an autonomous wish but require assistance to do so. We are not confident that the court has the necessary evidence on, or the courts below or the Secretary of State have had a proper opportunity to address this issue. Lady Hale and Lord Kerr would have issued a declaration of incompatibility. They hold that it is clear that Article 8 confers a right on an individual to decide by what means and at what point his or her life will end, provided that he or she is capable of freely reaching a decision. They further hold that in making no exception for those whose expressed wish to die reflects an autonomous desire rather than undue pressure, the current ban on assisting suicide is incompatible with Article 8. Lady Hale draws attention to the similarity between a procedure for identifying those who have made an autonomous decision, but require some help to carry it out, and other life and death issues currently made in the family division of the High Court and the Court of Protection. Lord Kerr emphasises that when courts make a declaration of incompatibility, they do precisely what Parliament, through the Human Rights Act 1998, has empowered them to do, and remit the issue to Parliament for a political decision informed by the court's view of the law. The remission of the issue to Parliament does not involve the court making a moral choice, which is properly within the province of the democratically elected legislature. Lord Kerr would also hold that there was no rational connection between the aims of Section 2(1) and the interference with the Article 8 rights. Lord Sumption, Lord Hughes, Lord Reid and Lord Clark accept that the courts have jurisdiction under the Human Rights Act to determine whether the current universal ban on assisting suicide is compatible with Article 8. But they consider that the question turns on issues which Parliament is in principle better qualified to decide, and that under present circumstances the courts should respect Parliament's assessment. The question requires a judgment about the relative importance of the right to commit suicide and the right of the vulnerable, especially the old and the sick, to be protected from direct or indirect pressure to do so. It's unlikely that the risk of such pressure can ever be wholly eliminated. Therefore, the real question they hold is how much risk to the vulnerable is acceptable in order to facilitate suicide by others who are free of such pressure or more resistant to it. This involves important elements of social policy and a moral value judgment, which are inherently more suitable for decision by Parliament as the representative organ of the Constitution. This, they say, is for three reasons. One, the issue involves a choice between two fundamental but mutually inconsistent moral values, the sanctity of life and the principle of autonomy, which are sensitive to a society's fundamental collective moral and social values, and upon which there is no consensus in our society. Two, Parliament has made the relevant choice on a number of occasions in recent years. And three, the parliamentary process is a better way of resolving issues involving controversial and complex issues of fact arising out of moral and social dilemmas in a manner which allows all interests and opinions to be expressed and considered. The second appeal: is the DPP's 2010 policy lawful? The Supreme Court unanimously allows the DPP's appeal. Section 2, subsection 4 of the Suicide Act precludes any prosecution of a person who has allegedly contravened Section 2 without the DPP's consent. It is one thing for the court to decide that the DPP must publish a policy, and quite another for the court to dictate what should be in that policy. The exercise of judgment by the DPP, the variety of relevant factors, and the need to vary the weight to be attached to them according to the circumstances of each individual case are all proper and constitutionally necessary features of the system of prosecution in the public interest. During these proceedings, counsel for the DPP indicated that under the 2010 policy, a stranger who is not profiteering from his or her action, but is assisting to provide services which, if provided by a relative, would not attract a prosecution, was most unlikely to be prosecuted. The Director will be able to consider further whether that indication should stand and whether, if so, the 2010 policy needs amendment without it being appropriate to order her to undertake any such review. In light of the Court's conclusion on the second appeal, Martin's cross appeal does not arise. We would not like to end without paying tribute to all those involved in bringing and pursuing these difficult cases to this court. The court will now adjourn.